No, y'all can't do that. The judge will kick you out the Zoom. Please do not do that. Thank you. Officer Norris.
Hey, Buck.
Hey, which position is Carter?
He spoke to her already?
Yeah, she's done talking to him.
He's two. You go first.
Okay, thank you.
All right, we go pull these guys.
ACDC going after medical, please, and thank you.
No.
Thank you.
All right, everyone, good afternoon. We're going to go ahead and get started.
Good
This
afternoon, Judge. How are you?
Good afternoon. Happy Juneteenth. This is the State Expedited Accusations Calendar in the State Court of Fulton County, Georgia. I am Judge Melanie Williams, and at this calendar today, we will address misdemeanor offenses for those individuals who've been recently arrested, but the cases have already been formally accused and bound over to state court. All defendants, you have an absolute right to remain silent. Anything you say regarding the facts of your case can and will be used against you. You also have a right to an attorney today. As you can see, I'm conducting this hearing by video. That means it's being broadcast over the internet as a live stream. It's also being recorded. When I ask if you understand your rights, I'm asking if you understand the rights I've just explained, as well as how I'm conducting the hearing today. Ms. Bridgewater, what is my reset date?
It is going to be July the 2nd.
All right. Those who receive a signature bond will be reset. Further notice, those who receive a surety or cash bond will be reset to state all purpose on July the 2nd of 2024, whereby aspects of your case, including your bond or contact, can be revisited. Have all defense attorneys had the opportunity to interview their clients?
Your Honor, there's still one person on the calendar I haven't talked to. That is Mr. Rivera. Montalban, I don't know if an interpreter
Oh,
is.
we need interpretation today.
Right. I don't
That
know
was
if
my
we-
next question. Will we have interpretation today, Ms. Bridgewater or Ms. Grace?
You know what? I sent the Mr. Bartel's email to Mr. Jordan, and he has not responded back with me on it.
Okay.
Stay
We
tuned, Mr. Bartel.
I'll check,
Okay, thank
I'll
you.
check for one, Judge. What type do
Thank
you
you.
need?
Spanish, I'm assuming. Is that
Okay.
correct?
I can try.
Yes, ma'am.
I'll try.
Okay. Are there any other complications? Anybody else who's requesting a breakout or anything of that nature before we get started?
Yes, good afternoon, Your Honor.
Good afternoon.
I'm actually here for a client that I represented yesterday. Judge Morrow stated I hadn't been able to get in touch with the complaining witness, who's also her mother. She's 17 years old, and I emailed, but all the wrong people. I thought Judge Mincy was on today. That's what the calendar said. So I'm just here to have that bond modified after I was able to get in touch with the mother, who will be able to co-sign, and I wanted
Judge Morrow indicated that he would change it,
yes.
and he didn't email you back to change it himself.
No.
Is this on the Ollie case?
Yes.
Okay, was the aunt gonna be the co-signer?
I listed her as the co-signer, but I hadn't been able to get in touch with any adult, but I was able to hear, the mom called me back yesterday after court.
And the mom's the victim.
Yes.
They're not gonna let, pretrial's not gonna do that. Is there any other person that can sign for her?
Well, Judge Morrow indicated yesterday that if I hear back from the mother, that the bond order could be modified.
I
And
don't
he didn't
think,
email you?
And she's
Yeah, I
going to
don't-
be on today.
That's not the issue. It's a pretrial issue typically, and not a Judge Morrow or me issue. Typically, victims are not allowed to come down to pretrial and co-sign. Who's from pretrial today?
Hi, Judge. I am Lethea Washington, and as far as I know, that will not be okay with pretrial.
Right. Pretrial is not going to let the victim be a co-signer.
I've had that before where, I mean, if she's 17 years old, there's no other guardian for her at this point. And I have had 17-year-olds, when the judge orders no violent contact, be able to go back home and be with their.
I understand, but again, you're asking me to, one, undo what Judge Morrow did, which I don't love.
I did.
Go ahead.
He was on the email, Your Honor.
He was, but
it's a holiday, I understand.
I know he didn't do it. We're gonna think about that for a moment, Mr. Todd. I understand what you're trying to do, and I do appreciate the situation, but we have two challenges here. First, pretrial that I've been told that victims are not allowed to act as co-signers. Second, Judge Morrow didn't respond to your request to do something different. So I will send him a message myself and see if he writes back to see what his thoughts are, because I typically am not going to undo what someone else did unless he gives me instructions to do something else.
Okay.
Okay. All right. But I do understand the mother is on Zoom.
She's joining now, she stated. Her name is
Tamika Ollie. I remember that case very well.
She just called
Okay.
me and said she's getting on.
Okay, well, we're gonna see what happens. All right, who do we have first at courtroom 2?
We're gonna start with
Yep.
question number 2, Mr. Carter, appearing medical.
Okay. All right, Mr. Carter, your case is 24 CR 003937H. In this case, you're charged with driving with your license suspended, improper backing, fleeing and eluding, and obstruction. Do you understand your rights?
Yes, ma'am.
All right, can I have the history, Ms. Washington?
Yes, this is the defendant's 43rd arrest. The last arrest was December 6, 2023 for a probation violation and an aggravated assault and burglary in the first charge. And there are 4 felony convictions outside of the 10-year period, a 2000 misdemeanor conviction for driving while license suspended or revoked, a 2005 arrest for driving while license suspended or revoked, a 2014 arrest for driving without valid license, a 2018 misdemeanor conviction for criminal trespass, a 2019 arrest for driving without a valid license. Also, in 2020, the defendant pled nolo to driving without a valid license and giving false name. There were 3 felony convictions, one being in 2019 for possession of a firearm by a convicted felon, a 2021 felony conviction for theft, which the defendant does appear to be on probation, serving 5 years. And that was out of Clayton County. The sentence date was November 1st, 2020. The defendant also appears to be on probation in Fulton County for failure to register and serving a 7-year probation sentence, with the sentence date being June 27, 2019. There are FTAs, one from 2013, one from 2016, and 3 in 2018, and the defendant meets the criteria for level 3. Nothing further.
All right, thank you. Ms. Hudak, is this your case?
It is, Your Honor. Thank you. Your Honor, this allegations did stem from an incident on June 17th of 2024. Officers attempted, excuse me, a traffic stop due to the defendant improperly backing up into an intersection. They activated their lights and sirens, but the defendant ignored those warnings and continued to drive for a few more minutes. He then came to a complete stop, exited the vehicle, and took off on foot with the officers in pursuit. He fled an apartment building and over a fence before falling approximately 10 feet. Officer Lee was able to ultimately detain him. His license has been suspended since a 2014 FTA. Officer Walker, the other officer involved in the pursuit, did sustain bruising and cuts during the foot pursuit. Your Honor, I believe his bond is currently set at a $4,000 cash bond. The state is suggesting a $10,000 cash bond due to his extensive record, his unwillingness or inability to comply with other court orders and probation. We would be asking for $4,000 for the fleeing, $4,000 for the obstruction, $1,000 on the suspended license, and $1,000 on the improper backing. Also, no driving without a license, without a valid license, and no drugs, alcohol, or weapons while out on bond.
Okay.
Good morning, Your Honor.
Good morning, Ms. Bader, please proceed.
Thank you. I'm having technical difficulties, so please let me know if you're having trouble hearing or seeing me. Mr. Carter does have a good address at 187 Maury Avenue Southwest, apartment 1708. That is an Atlanta address. He does have ties to the community. He's born and raised in Georgia, been here all of his life. He's 44 years old. He does have his GED and works at a chicken plant. All of his family is in Atlanta. He does have 3 children that he cares for with his wife. He currently has a broken leg. He's in medical and is unable to walk, which is why they are live from medical. His bond is currently sitting at $4,000. He is presumed innocent on these charges, and these are nonviolent charges. At this point, we're asking for the bond to not exceed the $4,000 if the court is willing, due to his medical status in the jail. It is not the safest place for him to be. We would ask for the driving while license suspended or revoked to be changed to a signature bond. And for the fleeing or attempting to elude to go from $2,000 to $1,000 so that his total bond is $2,000. Thank you.
All right, okay, defendant's bond is gonna remain as set at the 4,000 cash, 1,000 on each count. Actually, no. Okay, here's what, give me a second. I am so bad at math. Give me 1 second. Okay, defendant is gonna receive a $10,000 surety bond. It's gonna be $1,000 surety on the license suspended, $1,000 surety on the improper backing, 4,000 on the fleeing and eluding, and 4,000 on the obstruction. He's not to drive unless he has a valid Georgia license, and he's to have no alcohol, no drugs, no weapons as a condition of that surety bond. Is there anything additional?
No, Your Honor.
All right, best of luck to you, sir. That concludes your case. What do we have next?
Position 5, Ms. Evans from ACDC.
All right, has ACDC heard their right?
Yes, Your Honor, she was on with everybody else.
Perfect, thank you. And I see Ms. Chancey's logging in. Can we put Mr. Bartels into a breakout with Ms. Chancey and whoever, is the person that needs interpretation still at courtroom 2?
Yes, Your Honor, we have to log into courtroom 1.
All right, Ms. Chancey, can you please raise your right hand? And will you unmute for me 1 second? Do you swear and affirm that you will make an accurate translation from English to Spanish, Spanish to English to the best of your skills, knowledge, and ability?
Yes, Your Honor, I do.
All right, once the party is moved, Ms. Grace, will you move Mr. Bartels and Ms. Chancey into the breakout with the additional courtroom, please?
Yes, ma'am.
Thank you.
It's fine, Your Honor. I've got Mr. Cheneau, and then I've got the bottom half of the calendar, so I can do that now.
Okay, we'll try to take the top if we can.
Thank you.
And I'm sorry, in the midst of that, okay, Ms. Evans, your case is 24 CR 003938B. You're charged with 2 counts of simple battery family violence. Do you understand your rights?
Yes,
Say it again.
yes, Your Honor.
All right, thank you. Ms. Washington, can I have that history, please?
Yes, this is the defendant's 7th arrest with multi-state interaction in Massachusetts. The last arrest was August 28th, 2017 for destruction or injury of personal property, assault by means of a dangerous weapon, trespassing, disorderly conduct, and assault and battery, and that was out of Massachusetts. No disposition was listed. There appears to be an arrest from 2000 for an assault and battery by means of a dangerous weapon and assault, and that was also out of Massachusetts, but again, no disposition was listed. The defendant does meet the criteria for UJR. Nothing further.
Okay, thank you. Ms. Hudak, please proceed.
Thank you, Your Honor. These allegations do stem from an incident that occurred on 6/18 at 226 Anderson Avenue, Northwest Atlanta. Officers were called to the address and spoke to Mr. Roderick Nixon that said the mother of his children, 2 of his children, attacked him while he was sleeping. Officers found the defendant, later identified as Ms. Evans, walking down the middle of the street. They believed her to be under the influence of drugs and alcohol. They attempted to speak to her and she wasn't making any sense. They then spoke to Mr. Nixon again and Queen Evans, who is the child of Ms. Evans. Miss Queen Evans said that she texted her mom and said that she was in the bathroom. Her mother must have misunderstood and thought that there was another woman in the bathroom, which must have enraged her, causing her to attack Mr. Nixon. She then went up the stairs and attacked Queen, throwing her to the ground and hurting her knee. Your Honor, we are recommending a $2,000 cash bond, $1,000 on each count, no drugs, alcohol, or weapons, a substance abuse evaluation, no further contact with Mr. Nixon or Ms. Queen Evans and a stay away from the residence at 226 Anderson Avenue with a one-time police escort to get her items. I do believe, Your Honor, that I see Mr. Roderick Harris and who I believe is Ms. Evans on the Zoom, and I would ask you to sound for them at the appropriate time.
And just to clarify, you're requesting a cash bond?
Yes, Your Honor.
Okay. All right, Mr. Nixon, please unmute and raise your right hand if you'd like to make a statement. Do you swear and affirm the testimony you give today be the truth to the best of your knowledge under the penalty of perjury? Mr. Nixon?
Yes, Your Honor.
All right, you can put your hand down. Let me give
Yes.
you some instructions before you tell me anything. This is a bond hearing and the defendant is charged with a misdemeanor offense, which means she's entitled to a bond today. What I am most concerned with is any concerns you have for your safety and whether you wish to have contact with the defendant. If you disagree with something Ms. Hudock said, that's not what's of most critical importance today, as we're not sentencing the defendant. So in light of those instructions, what would you like to tell me, Mr. Nixon?
Well, I had already proceeded with the eviction. She was being evicted, so as long as she's not back here, that's fine. Her daughter is sitting next to me, and her brother is sitting next to me, so they're willing to give any input as possible. But
Well, again, what I
this,
want to know, I'm gonna let you finish, but do you wish to have any contact with her?
No.
And do you have any concerns for your safety?
Yes.
Okay. And is anybody sitting there, Queen Evans?
She's here.
That's Queen Evans. Do you wish to make a statement? Do you wish to make a statement?
No.
Okay, that's more than fine. That's okay. Thank you. I appreciate you coming to court and making those statements today, okay? Ms. Bader, please proceed.
Yes, Your Honor. Miss Evans is 47 years old. She is a high school graduate. She currently works at FedEx. She does have a brother who lives in Decatur and an aunt who she has stated that she with. She does have two with Mr. Nixon. It's my understanding that there is a third child in the home who she has custody of. So just to keep that in mind in terms of when as a police
Ms. Bader, you're breaking up pretty bad. You asked me to keep what in mind?
It's my understanding that there's a third child in that home that is not by Mr. Nixon, that is Miss Evans' child. So for her to be able to have a police escort to retrieve her belongings and her child. And Judge, we're asking for a signature bond. Miss Evans is unable to afford a bond at this time.
All right, thank you. Defendant is going to receive a $2,000 surety bond. She is going to be $1,000 on each count. She's to have no contact with the alleged victim. She can return one time with a member of law enforcement to get any items, and she's to stay away from that location. Have no alcohol, no drugs, no weapons as a condition of that surety bond. And as a reminder, she will be reset to the all-purpose calendar on the 2nd of July. Is there anything additional?
No, Your Honor.
Your Honor.
Very quickly, I've heard from you, Mr. Nixon. What would you like to tell me?
So concerning the third child, this is the second victim. So I'm not sure if you're allowing her to pick up her, or you don't want her contact. I understand me, but her child here is the other victim.
Right.
So I'm not sure if she's going to be allowed to. That's why her brother's here, and her brother is willing to take her child.
For the time
That's
being.
not mine.
Okay. Okay. I think that's what we're going to do for the time being. We're going to order the no contact, but that can be revisited at a later date. All right. Thank you for clarifying that point, Mr. Nixon.
You're welcome.
All right, best of luck to all parties involved. We can move to the next case.
Good afternoon, Your Honor. This is courtroom 2. This is going to be position number 8, Miss Lowry, position number 8.
All right, thank you. Ms. Lowry, your case is 24 CR 003941G. You're charged with battery, family violence, and cruelty in the third. You understand your rights?
Yes, Your Honor.
All right. Ms. Washington.
Yes, this is the defendant's first arrest, no prior criminal history, and the defendant meets the criteria for level 1. Nothing further.
All right, thank you. Mr. Pierre Thomas, please proceed.
Good afternoon, Your Honor. Brief facts of the case is that it appears that on 6/18/2024, the officer responded to 53 Buffington Road in reference to a fight. The officer met with the victim, who happens to be Mr. Robert Fields in this case, ROBERTFIELDS. Second victim is a juvenile child, initials K and L. Mr. Fields advised that he was at the location, or he was at the location when the officers arrived. He advised that he was texting other women, and the defendant caught him doing so. The victim further advised the defendant caught him texting the other woman, and she took his phone, at which point she threw his phone at him and began hitting him, which resulted in the laceration to the left side of his face. The victim advised that that at this time he restrained her in self-defense by holding her so that she would not continue to hit him. He also stated that the defendant's son, initials K and L, birthday, looks like year is 2021, was close by and was crying when he observed the incident. The officer observed the phone had been cracked on its screen, and that the victim stated that he believed that that's how he got the cut. The victim also advised that the defendant was pregnant with his child at the time. The recommendation from the state, Your Honor, is a signature bond through the pretrial services, the completion of a family violence intervention program, no alcohol, drugs, or weapons, no contact with the victim, and a stay away from the incident location. And if we can sound for the victim in accordance with Marcy's law, that'd be greatly appreciated.
Okay. And the victim is Mr. Robert Fields, is that correct?
That is correct, Your Honor.
All right, is Mr. Field present on this Zoom conference and wishes to make a statement? Hearing, seeing none. Mr. Bartels, do you object to the signature bond through pretrial?
We do not, Your Honor. Just to give the court a little background, it looks like the report notes that Ms. Lowry also had a laceration on her lip. She did indicate to me that Mr. Fields was the primary aggressor and she was defending herself. However, she understands that that will be addressed at a later date in terms of evidentiary matters. But as pretrial indicated, she doesn't have a record, so we certainly would ask for a signature bond from the court. She is asking for a no further violent contact. I did try to get in touch with Mr. Fields, but I wasn't successful, and it looks like he is not here today. She did indicate that Mr. Fields may be moving to another residence, so we would ask that if the court does put in a no further contact order, that there be an exception for that, or that she be able to live at this residence if Mr. Fields is not present there, if there is a no further contact order. Regarding the FVIP, we would oppose that, especially when our position is that she was defending herself. That's 24 weeks. It's quite onerous.
I'm not going to do that. We don't have to go through that, Mr. Bartels. Okay. If you know me, I don't do that typically here. As it pertains to the minor child, though, is that her child?
Yes, it is.
Okay. And if go ahead.
I'm not aware. Well, let's see. Are they?
Okay.
Yeah,
are they?
I'm not aware. I don't believe they're married, Judge. And I'm not aware of him having like any legal rights in that regard.
Okay. All right. Here's what we're going to do. Defendant's going to receive $4,000 signature bond through pretrial services. She's going to take the 1-day anger awareness course. She's going to have no contact with Mr. Fields. However, she's going to have no further violent contact with the minor child. She is going to stay away from that location if Mr. Fields resides there. To make that determination, she can return with law enforcement one time. Additionally, she's to have no drugs, no alcohol, no weapons as a condition. Is there anything additional?
Nothing, Your Honor. Thank you.
Your Honor, just to confirm for pretrial, we're doing level 1.
Yes, at level 1, at the recommended level. Thank you. Ma'am, if you have a question, the best thing for you to do is to speak to Mr. Bartel so that you don't infringe upon your right to remain silent and accidentally say something the state will use against you. Do you have a question about the bond very briefly? And I'm sorry, the bond is going to be broken down 3,000 on count 1, 1,000 on count 2.
Okay,
I just wanted to tell Ms. Bartels we are legally married in the state of Georgia.
you are. Okay. All right. Thank you.
All right, the ruling will stand. All right,
Thank you, Your
best of luck to all parties. Who do we have next?
Your Honor, I apologize. What was that bond amount again?
4,000 through pretrial, 3,000 count 1, 1,000 count 2.
Thank you. We go to that. Next, can we go to the add-on calendar? And it's gonna be.
Is that Mr. Bartels before we do that?
That is Ms. Vitter's case, Your Honor.
Okay, as long as it's not yours. Okay, because I was gonna ask if we could put Mr. Bartel into that breakout now.
They should be logging on, so.
Okay.
I just saw him.
Yeah, they on now.
Yeah, so bye-bye, Mr. Bartel. See you in a moment. All right, let's go to the add-on. This is Mr. Michael Friedman, 24 CR 003947F. Do you understand, in this case, you're charged with criminal trespass. Do you understand your rights?
Yes, I do.
All right, Ms. Washington.
This is the defendant's 19th arrest with multi-state interaction in Nevada and Georgia. Last arrest was April 24th, 2024 for criminal trespass, which appears to be an open case. The defendant received first offender treatment for dangerous drugs, purchase, possession, or sale of marijuana, possession of a firearm during the commission, purchase or possession of a controlled substance, and that was in 91. One misdemeanor conviction outside of the 10-year period for a theft case, a 2013 arrest for simple battery, family violence, simple battery, and battery, and that was out of Cherokee County, which was no price. The defendant also received first offender treatment in 2015 for possession of cocaine and possession of marijuana less than an ounce. There is one FTA in 2012, and the defendant meets the criteria for level 2. Nothing further.
All right, thank you, Ms. Hudak.
Your Honor, thank you. I'm going to actually start at the end of the beginning of what pretrial said, which was he did appear before the Honorable Judge Mincy on April 25th, wherein he was charged with criminal trespass and given a $2,000 good bond in order to stay away from 985 Laurel Mill Drive, Roswell. Despite that stay away order and that pre-bond condition on 6/18, he did in fact go back to that very same address and was caught on the premises. He told officers that his bond condition was changed and that he was actually permitted to go back to that address. The owner of the address, Mr. Octaviano Velasquez, said that he had been renting a room to Mr. Friedman prior to the April incident, that he was removed from the property at that time, that despite the fact that there has been a no contact and a stay away order, that he and Mr. Velasquez's grown son have realized that Mr. Friedman has gone back to the property on a number of occasions, sometimes sneaking in when Mr. Velasquez is at work. So because the fact that this is actually an aggravated stalking case, the district attorney's office today chose not to accept it into Superior Court. And despite the fact that there's a $2,000 good bond on the previous case, this time we are asking for a $10,000 surety bond to ensure that Mr. Friedman either stays in the jail or gets it into his head that he is not permitted anywhere near 985 Laurel Mill Drive and needs to have absolutely no contact with Mr. Velasquez.
All right, is it Vasquez on this line?
It is spelled Velazquez.
Oh, Velasquez. Is Mr. Velasquez present?
And I don't believe he was going to be because he was at work.
That's fine.
But we have had contact with him.
And we've sounded. So Ms. Bader, please proceed.
Yes, Your Honor. First, I'd like to ask a question. So it's my understanding then that we're addressing the violation of a family nonviolence order, and is that for violation of a protective order?
I got it.
That's what,
Criminal trespass is the charge that's on the calendar.
okay, because I'm looking at his booking information and I just want to make sure that
It came in. He was booked on a violation of a protective order, but that was an incorrect charge by the police officers. In fact, it is a violation of a bond condition at the 24 CR case.
And Your Honor, and I'll start by saying, you know, Mr. Friedman, he is 56 years old. He has lived in Georgia his whole life. He does have a degree in biology from Georgia State. He's previously worked as a veterinarian technician. So on the day of his last bond hearing, he was in medical. He had a car accident in March where he suffered from 7 broken ribs, a collapsed lung, and he's had a lot of residual health issues since then from that car accident and was in medical on the day of his bond hearing. It seems like there was a lapse in communication where, because it was a nonviolent charge, he was under the impression he could go back to the address, reached out. He said he reached out and was under the impression that he could go back to the address. He has a different address he can live at, and is not it was a lapse in communication is my understanding due to him being in medical on the last bond hearing day. I have personally spoken to his family friend with whom he can live. His name is Robert Jerry Lewis. I verified his address today. It is in Alpharetta, Georgia, 238 Brook Drive. He's known him for about 10 years. Again, I personally spoke with him today. He has a different place to go. We're asking for a signature bond for him to go to that address, Your Honor.
All right, defendant's gonna receive $1,000 surety bond. He's to absolutely stay away from that location. Have no alcohol, no drugs, no weapons as a condition. Is there anything additional? All right, best of luck to you, sir. Who do we have next?
Here you go. May I please say something?
I don't recommend it.
Mr.
I don't recommend it.
Is not the owner of the house. He is one of our tenants. He moved in after I moved in, so all that is erroneous. The owner of the house is Rocky. I can't remember his last name. He is actually me in charge of the house.
Why don't you can he give Ms. Bader a call? And then if she needs to I don't want you to say something that's going to infringe upon your right to remain silent. You might think you're helping yourself and you might end up saying something else. Ms. Bader, can you call the jail?
And Mr. Friedman, this isn't going to really affect the bond issue, so I'll give you a call.
Yeah, I think that's for the best.
None of the information was correct. Can I please at least give some of the correct information?
And I'm gonna let your attorney give the jail a call so you can tell her and not me. Okay.
Ms. Bader, that's gonna have to be done at the end of the counter. I need you to go to the back.
Thank you.
To the back row. Next, Your Honor, we're gonna go to position number 1. It's gonna be Mr. Brooks.
All right, good afternoon, Mr. Brooks. Your case is 24 CR 003934 C, in which you're charged with simple battery. You understand your rights?
Ma'am, I do.
All right, can I have the history, Ms. Washington?
Yes, this is the defendant's 14th arrest. The last arrest was November 15th of 2022 for driving while license suspended or revoked. There's a 2009 misdemeanor conviction for driving while license suspended or revoked and possession of marijuana less than an ounce. The defendant pled nolo in 2011 for driving while license suspended or revoked. The defendant does appear to have a open case in Fulton County from 2020 for theft by taking, which appears to be dormant. There is also a hold with APD for an FTA. The warrant date was March 10, 2023. There's one FTA in 2012, and the defendant does meet the criteria for level 2. Nothing further.
All right, thank you. Ms. Hudak, please proceed.
Thank you, Your Honor. This incident does stem from an altercation that occurred on June 18th of 2024 at 3200 Stone Road. Essentially what was going on is it appears that Mr. Brooks's daughter, Michelle, was being bullied by other young folks. They would wait for her to get off the school bus and they would shoot her with BB guns and start to fight her. And so yesterday on the day in question, those young folks were once again waiting for her to get off the school bus. The alleged victim in this case, Mr. Orlando Spencer, who is a juvenile, did in fact trip Michelle Brooks. And that started a fight. At that point, Mr. Brooks came down, tried to have some words with Orlando Spencer. He doesn't remember what Mr. Spencer responded back, but it was not positive. And so the allegation is that Mr. Brooks did smack Orlando. This started another fight with other juveniles that Orlando was involved in. Orlando was injured, but it doesn't appear that he was injured by Mr. Brooks. Given the circumstances of this case, the state's recommendation is a $1,000 signature bond through the jail and no further contact with Orlando Spencer.
I'm inclined to grant that. Ms. Bader, any objection?
No objection, Your Honor.
Before we do that, let's sound for Mr. Spencer. Mr. Spencer, are you present? All right. In light of the facts before me, defendant will receive a $1,000 signature bond through the jail. He's to have no contact with Mr. Spencer. Best of luck to you, Mr. Brooks. That concludes your case. All right. All right. Take care. Have a good day. Who do we have next?
Next, we're going to position number 4, Mr. Clark.
All right, Mr. Clark, your case is 24 CR 003936Y. You're charged with hit and run. And I think that's the only charge. You understand your rights?
Yes, ma'am.
All right, Ms. Washington.
This is the defendant's second arrest. The last arrest was February 9th of 2009 for possession with intent to distribute and trafficking oxycodone. The defendant does meet the criteria for UJR. Nothing further.
All right, Ms. Hudak, please proceed.
This allegation does stem from an incident on May 22nd of 2024. At that time, officers from College Park responded to Old National Highway where they spoke to right now the unnamed victim that was a driver of a car and his passenger, Ms. Jacqueline Smith. Essentially, they said that they were driving on 85 southbound when a black Chevy Camaro struck the side of their vehicle and then continued to drive off. The passenger, Ms. Jacqueline Smith, hit her head on the door during the collision. The driver and his passenger were able to make note of the make, model, and tag number of the Camaro. The officers ran the registration and they pulled up the defendant, later identified as Mr. Clark's photograph. They showed the photograph to the driver and Ms. Smith, and they positively identified him as the driver. Your Honor, we would ask for a $2,000 surety bond and no drugs, alcohol, or weapons during the period of the bond.
All right, Ms. Bader, please proceed.
Yes, Your Honor. Mr. Clark has a good address in Doraville, 3214 Valley Bluff Drive, apartment 203. He has been in Georgia. He's 39 years old. He's been in Georgia for 21 years. His father was in the military, so they moved around a lot. And then he came to Georgia where he graduated from Clark Atlanta University and has been here ever since. He's been working for 19 years at the same job at UPS and worked up the ranks. He's now a frontline supervisor. Judge, he is presumed innocent on this case. We're asking for a signature bond.
All right, I'm sorry, Ms. Hudak, did you request other conditions other than the surety bond? On the surety bond, the state request conditions?
No, just no drugs, alcohol, or weapons during bond, Your Honor.
All right, in line with the information before me, defendant's going to receive a $9,000 signature bond through the jail. He is to have no alcohol, drugs, or weapons as a condition. Is there anything additional?
No, Your Honor.
All right, best of luck to you, sir. Who do we have next?
Next is going to be position number 7, Mr. Ronaldo Johnson.
Okay, Mr. Johnson, your case is 24 CR 003940E. You are charged with battery family violence. You understand your rights?
Yes, ma'am.
All right, Ms. Washington, can I have that history, please?
Yes, this is the defendant's 12th arrest. The last arrest was May 22nd of 2006 for a probation violation. There was a 1994 arrest for armed robbery, a 95 felony conviction for violating the Controlled Substance Act, a 96 arrest for aggravated assault, a 95 arrest for hijacking a motor vehicle and armed robbery. The defendant does meet the criteria for level 1. Nothing further.
All right, thank
Brief
you,
facts
Mr.
of the
Connor.
case. Brief facts of the case is that on 6/18/2021, the officer arrived at 615 Versailles, Versailles Drive Southwest in Fulton County, Georgia, in reference to an assault call. Upon arrival, they met with Miss Aisha Murray, Ayeesha Miss Murray informed the officer that her uncle, who happened to be the victim in this case, Ernest Johnson, ErnestJohnson, was assaulted by his son, the defendant, at the location of 310 Lori, Lori Lane in Riverdale, Georgia, 30296. She stated that the victim and the defendant lived together. The defendant attempted to illegally put the victim out by dumping his belongings at her mother's old residence. She stated that she found the victim dropped off at that location with a laceration from the middle of his head to his forehead and several swelling marks in his face. The victim stated that his son, the defendant, punched him multiple times in the face, then dropped him off at his aunt's old residence due to him thinking that she still lived there, and drove off. Before the officer arrived, the officer observed and noticed that the defendant had a major laceration from the middle of his head to his forehead and had a swollen eye and swollen cheeks and a cut mouth. Our office, unfortunately, was not able to get in contact with Mr. Johnson, so if we can sound for him in accordance with Marcy's law at the conclusion of the request, that'd be greatly appreciated. But the request is a $2,000 surety bond, no alcohol, drugs, or weapons, the completion of a family violence intervention program, no contact with the victim in this case, and a stay away from that incident location. Nothing further to add.
All right, and the victim was Mr. Johnson. Mr. Johnson, if you are present, please unmute your screen if you'd like to make a statement. Hearing, seeing none. Ms. Bader?
Yes, Your Honor. I've received information from Mr. Johnson and his family members who I've spoken to today that the alleged victim in this case is deceased. I heard
Recently deceased, Ms. Bader?
in January. This warrant is from, I believe the state said 2021, which would be out.
That is correct. It's from 7/21/2022. The incident date is.
Okay, so 2022. So almost outside the statute of limitations, but this is 2 years old. Additionally, yeah, so between then and now, Mr. Johnson has not had any encounters with law enforcement. So he's been arrested yesterday on warrants from 2 years ago. The alleged victim has passed away. I guess going to Ayala factors, I thought the state might have been able to find that out before today and hopefully get this dismissed. I have hit the obituary information that I can forward to the state, but I'll just go to Ayala now. I mean, he's 48 years old, born and raised in Georgia. As you heard,
I'm going to cut you off. In light of the information before me, I'm inclined to give your client a signature bond through the jail. Do you have an objection to that?
No objection.
And I'm assuming we don't need to stay away from the victim in this case.
No, Your Honor.
All right, so defendant is going to receive a $6,000 signature bond through the jail. He's to have no alcohol, no drugs, no weapons, and no further conditions on that bond. And Ms. Bader, I would appreciate if you would still send that information so the state can take a look at it.
Thank you. I will.
All right, best of luck to you, sir. Who do we have next?
Everyone else is Mr. Bartell's client.
Is Mr. Bartels back?
Nope.
Ms. Atai, no, I haven't gotten a message from Judge Morrow, and I sent a message over to pretrial to see about that. I understand that that's what you've been told, that they can do that. I've had several of these that I signed kick back. and they still wouldn't let the person pick up.
Well, in my experience, that I mean, I have even recently had the
Well,
complaining.
I don't want to sign something that sets up. Miss Ollie, while you're on the line, do you know of anyone else that can come down and sign your daughter out that's not you? That would just
We
make
don't
life
have
a lot easier if someone else can come do it.
we don't have any relatives here,
It
Your
doesn't have to
Honor.
be a relative. It just has to be an adult over 25.
I can try to find someone to come down there, but to be honest with you,
Why don't you try that? That's our best shot right now. Okay. While we're still on the line, why don't you try that now and then give us the name of that person?
okay, I'll try that. But I just want to state something, Your Honor. I'm a little no. Okay.
Don't trust me. Don't say anything. Let's see what we can do with this on this measure. Okay. Thank you.
Okay.
All right. I guess we are on hold. All right, everyone, please hold. All right. Are we back?
Yes, ma'am, we're ready.
All right, let's take the interpretation case. What position was that?
Position 11.
Okay. Good afternoon, Mr. Rivera. Your case is 24 CR 003944C.
Buenas tardes, señor Rivera. Su número de caso es 24 CR 003944E. Sí, C, perdón.
In this case, you are charged with battery, family violence, and cruelty to children.
En este caso, usted está acusado por golpes y lesiones, violencia familiar y por crueldad ante menores en el tercer grado.
You have an absolute right to remain silent. Anything you say can and will be used against you.
Usted tiene el derecho de guardar silencio. Todo lo que diga puede y será usado en su contra.
You have a right to an attorney today, and Mr. Bartels is here to represent you.
Usted tiene derecho a tener un abogado y el señor Bartel está aquí para representarlo.
And I am conducting this hearing by video. Do you understand your rights and how I'm conducting the hearing today?
¿Entiende usted? Estoy conduciendo esta audiencia a través de video y usted entiende sus derechos y cómo estoy conduciendo esta audiencia. Yes.
All right, thank you. Miss Washington, can I please have his history?
This is the defendant. I'm sorry.
No, that's okay. Go ahead, madam.
This is the defendant's second arrest.
Este es el segundo arresto de este acusado.
The last arrest was May 25th, 2023. I'm sorry, the last arrest was July 13th, 2014 in Texas for alien inadmissibility.
El primer arresto fue el 13 de julio del 2014 por inadmisibilidad por indocumentación.
The defendant meets the criteria for UJR.
El acusado cumple los requisitos para el proceso de UJR en sus siglas en inglés.
All right, Mr. Pierre Thomas, please proceed.
A brief fact of the case is that on June 18th, 2024, the officer was dispatched to 701 Belcourt Parkway in reference to a domestic disturbance.
Los hechos del caso es que el 18 de junio del 2024 el oficial fue despachado al 701 de Belcourt Parkway debido a molestias por discusiones.
The caller advised that her husband had struck her.
La persona que llamó declaró que el acusado la había golpeado.
The officer spoke with the caller, the victim in this case, Miss Orlandra Ortega, Alondra Ortega, who was visibly upset at the time.
El oficial habló con la persona que hizo la llamada, en este caso la víctima, la señora Alondra Ortega, que estaba visiblemente angustiada.
Victim advised that her and her husband, the defendant, had gotten into a verbal altercation over the victim wishing to leave. The officer was able to observe large red marks and scratches to the left side of her face that appeared to be fresh.
La víctima declaró que ella y el acusado habían tenido un altercado verbal referido a el deseo de ella querer ir y entonces luego el oficial observó que habían unas marcas en la mejilla izquierda que aparentemente se veían recientes.
The officer also observed a burn mark near the victim's right elbow that it did not appear to be fresh.
Which mark was not fresh, sir? I'm sorry.
A burn mark near the victim's right elbow.
Oh, right elbow. Okay. Thank you.
Mhm.
También el oficial observó una marca en el codo derecho que no parecía ser reciente.
Okay. The victim advised that during the course of the argument, the defendant went outside and came back inside and assaulted her.
La víctima declaró que después de tener esta discusión, el acusado se retiró, pero después volvió a agredirla.
The victim advised that the defendant grabbed her by the neck, threw her to the ground, and hit and struck her.
La víctima también declaró que el acusado la agarró, la tomó del cuello, la tiró al piso y golpeó.
The victim advised that prior to the officers arriving, the defendant asked her not to call the police and told her that she could leave in the morning.
Cuando ella llamó a la policía, el acusado le pidió que por favor no llamara a la policía y que ella podía irse al otro día a la mañana.
When originally asked about the incident, the defendant initially lied about the existence of an altercation.
Cuando se interrogó acerca del incidente, el acusado al principio mintió acerca de la existencia de un altercado entre ellos.
Unfortunately, our office has not been able to get in contact with the victim, so if we could sound for her in accordance with Marcy's law, that'd be greatly appreciated at the end of the state's request.
Desafortunadamente la fiscalía no ha podido contactarse con la víctima. Si por favor podríamos hacer un llamado para ver si está presente en la plataforma de Zoom, te lo agradeceríamos mucho.
Your Honor, given the presence of the violent act in the matter and the potential for false imprisonment, the state's request is a $3,500 surety bond, no alcohol, drugs, or weapons, the completion of a family violence intervention program, the stay away from that incident location, and no contact with the victim. Nothing further to add from the state.
Debido a este acto violento y también por haberla tomado de la manera en que le impidió moverse, la fiscalía está pidiendo una fianza de $3,500 bajo garantía. Queda prohibido el uso de drogas, alcohol y armas, que debe someterse a un programa de intervención de violencia familiar, mantenerse distanciado del domicilio, de la dirección, de la residencia y no tener contacto con la víctima.
All right. Ms. Chancey, will you please sound for Ms. Ortega?
Señora Oralonda Ortega está presente en la plataforma de Zoom. Por favor, prenda su cámara, salude, avísenos si está presente para hablar con la señora jueza.
All right, we've sounded in Spanish. Ms. Ortega, if you're on the line and wish to make a statement, please indicate by turning on your camera.
Por favor, si está en la línea, indique que está presente prendiendo su cámara.
Hearing none, Mr. Bartel.
Yes, Your Honor. Thank you. First, we would have to object to the characterization of my client as lying to police. It's not clear whether an interpreter was present or how they knew what it was that my client was saying. I wasn't there. Nobody from the state was there. The alleged victim is not here. The officers aren't here. We don't have any video. So I would object to him being characterized as lying, first of all.
En primer lugar, quisiera objetar la caracterización que se le está dando a mi cliente acerca de mentirle a la policía. No hubo intérprete, no sabían qué era lo que él estaba diciendo, la fiscalía no estaba ahí, nadie estaba ahí y ni tampoco hubo un video que compruebe. Por eso no objeto que se lo caracterice a mi cliente de haber mentido.
He does deny that he hit her or that he told the police that he hit her.
Él niega que haberla golpeado o decirle a la policía que le había golpeado.
And the warrant says the burn mark allegedly occurred in a separate incident, but it doesn't attribute any responsibility for that.
En la orden de arresto se menciona la lesión del codo, que no tiene nada que ver con este incidente, ocurrió en uno diferente.
Mr. Rivera indicates that that was the result of a cooking accident.
El señor Rivera indicó que esa lesión fue ocurrida a causa de un accidente cocinando.
I am advised that Mr. Rivera works full-time as a carpenter with Georgia Interiors and Exteriors.
Quisiera decir que el señor Rivera trabaja a tiempo completo con la compañía Georgia Interiors and Exteriors.
And I'm also advised that he has family in the metro Atlanta area. That includes 2 uncles, a sister, cousins, and his 2 children.
Él también me ha dicho que tiene parientes en el área de Atlanta, como 2 tíos, una hermana, primos e hijos.
Given all that, we are asking the court for a signature bond since pretrial has indicated he qualifies.
Y después de todo esto, quisiera pedir a su señoría que se le otorgue una fianza bajo firma, ya que los servicios previos al juicio han advertido que él cumple los requisitos.
And if the court is going to order a no further contact provision, he indicated he would be able to stay somewhere else.
Y si su señoría indica que no puede tener más contacto con la familia, mi cliente ha indicado que él tiene un lugar a donde ir.
And we would just ask that he be able to return once to get any belongings if there's a no further contact order.
Que si hay una orden de no tener más contacto, pido que mi cliente se le permita ir una vez para retirar sus pertenencias personales del lugar.
If the court is not inclined to grant a signature bond, we would ask for a $1,000 bond on each charge for a $2,000 surety bond.
Si su señoría no tiene la inclinación de darle una fianza bajo firma, pedimos que se otorgue una fianza de $1,000 por cargo bajo garantía.
And that's all from the defense, Your Honor.
Y el total de $2,000. Y eso es todo por parte de la defensa, su señoría.
All right, defendant is going to receive a $3,500 signature bond through pretrial services.
Ordeno una fianza de $3,500 bajo garantía a través de los servicios previos al juicio.
Broken down, 3,000, count 1, 500, count 2.
Serían $3,000 de fianza bajo firma para el cargo 1 y $500 por el cargo 2.
He's to have no contact with the alleged victim and stay away from that location.
Él no puede tener más contacto con la víctima alegada y no debe regresar a esa dirección de la residencia.
He can return one time with a law enforcement officer to get any items.
Para obtener sus pertenencias personales, él puede regresar solo una vez con un oficial de la policía.
And he's to have no alcohol, no drugs, no weapons.
Y se prohíbe el uso de drogas, alcohol y armas.
Is there anything additional?
Hay algo level.
Okay.
Thank you, Your Honor. Nothing further from the defense.
That'll be level 1.
Thank you.
Nothing further from
Y será a través de los servicios previos al juicio el nivel 1. Nada más de ninguna de las partes.
All right, that concludes your case, sir. Best of luck to you.
Eso termina su caso. Le deseo la mejor de la suerte, señor.
All right, Miss Chancey, can you sound to see if there's anyone else who needs your assistance before we go?
Yes, Your Honor. ¿Hay alguien que necesite un intérprete para hablar con la señora jueza? Por favor, avísenos.
All right, hearing none. Thank you, Ms. Chancey. Take care. Have a great
Thank
afternoon.
you.
Thank you,
You
Ms.
too,
Chancey.
Your Honor. Bye-bye. You're welcome, sir. Bye-bye.
Next, Your Honor, is gonna be position number 3, Mr. Chenault.
All right, Mr. Chenault, your case is 24 CR 003935D. You're charged with battery, family violence, and criminal trespass. You understand your rights?
Yes, ma'am.
All right, Ms. Washington.
This is the defendant's second arrest. The last arrest was September 28th, 2021 for driving while license suspended or revoked, in which the defendant pled nolo to, and this is the defendant's only arrest. The defendant does meet the criteria for level 1.
All right. Thank you, Ms. Hudak.
Thank you. This incident did stem from an allegation on June 12th, 2024. Sandy Springs officers responded to 300 Carpenter Avenue, Northwest Atlanta, where they spoke to the victim, Miss Brianna Brevet, Brevet, who said that they got into an argument and he broke the coffee table and struck her in the face with an Xbox. The officer saw the coffee table had legs broken off and observed a contusion and dried blood on her face consistent with being struck by an object. After the fight, he left the home. Your Honor, the state is recommending a $2,000 surety bond, $1,000 on each count, no further violent contact with Ms. Brevet, no drugs, alcohol, or firearms while out on bond. And I do believe Ms. Brevet is on the Zoom, and so would ask that you sound for her, Your Honor.
All right, Ms. Brevet, if you wish to make a statement, please raise your right hand and turn on your camera. You are not required to make a statement, however. All right, unmute. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes.
All right, what I'm most concerned with again is any concerns you have for your own safety and whether you wish to have contact with the defendant. If you disagree with the facts, as Ms. Hudak stated, I'm not primarily concerned with that, as there will be other proceedings and the defendant is not being sentenced today. So what would you like to tell me?
That I would still like contact with the defendant, and he is in no concern of my safety for me. I'm not
All
worried
right.
about it.
All right, thank you. Mr. Bartels, in light of the information before me, I'm inclined to grant your client the signature bond through pretrial, require the 1-day anger awareness course, and no further violent contact with the alleged victim. Any objection to that?
No, Your Honor, that's what we would ask for. Thank
All
you.
right. Defendant's going to receive a $3,500 signature bond through pretrial, $3,000 on count 1, $500 on count 2. He's going to take the 1-day anger awareness course, have no further violent contact with the alleged victim, have no alcohol, no drugs, no weapons as a condition. Is there anything additional?
Nothing further, Your Honor. Thank you.
All right. Best of luck to all parties involved. What do we have next?
Next is gonna be position number 9, Terrence Milton.
All right, Mr. Milton, your case is 24 CR 009423J. You're charged with obstruction, criminal trespass, and making terroristic threats. Do you understand your rights? All right, Ms. Washington.
This is the defendant's 17th arrest with multi-state interaction in Georgia and Alabama. The last arrest was February 25th, 2022 for an FTA in Cobb County. Sorry, I'm having technical issues. There was a 2005 arrest for assault in the 3rd in Alabama, but no disposition was listed. 2010 misdemeanor conviction for theft by shoplifting. 2018 misdemeanor for driving while license suspended or revoked. A 2019 felony conviction for driving while license suspended or revoked. A 2021 arrest for 3 counts of willful obstruction, which was no pros, and there is a misdemeanor conviction for a DUI. A 2018 misdemeanor conviction for driving while license suspended or revoked. A FTA in 2020, 2 FTAs in 2022, and the defendant meets the criteria for level 2. Nothing further.
All right, thank you, Mr. Pierre Thomas. Please proceed.
Your Honor, brief facts of the case is that on June 18th, 2024, one moment. It says June 18th. June 18th, 2024, the leasing office manager, the victim who was located at 370 Northside Drive, Northwest Atlanta, Georgia, which is the location of the Wesley on Beltline apartments, notified the officer of a verbal dispute between a tenant and her staff members. The victim stated that the defendant threatened her assistant manager at the leasing, who was a leasing consultant, and the maintenance worker by telling them that he was going to beat their ass after becoming upset with a staff member for not working fast enough and being on the phone while he was waiting to be attended to. During the verbal dispute, the defendant had to be escorted off the property to avoid a physical conflict with the maintenance worker, whose name is Quan. Upon receiving the information, the victim and the officer walked to the apartment 2028 and spoke with the defendant about the incident and issued him his second criminal trespass letter. The letter stated that the defendant could no longer be allowed inside the leasing office due to the staff's safety concerns. As the officer read the letter, the defendant became upset and started yelling, screaming, and cursing the victim and the officer out. He then shut the door closed and said to get the FUCK away from my door. The officer then advised him that if he went back into the office, he would be arrested for trespassing. He then responded, "I don't care." While walking away from the apartment, the defendant ran towards the victim in this case being Tara, Tara Scott, Scott, with an object in his hand, which was described as a yellow coat, and he threw it at her. Fortunately enough, he missed her face, and then he threatened to cause harm to her. All of this happened in front of the officer. While he was being escorted to the patrol car by the officer, he snatched his arm away several times and had the audacity to spit in the officer's face. Unfortunately, our office has not been able to get in contact with Ms. Scott, but if we could sound for her in accordance with Marcy's law, that'd be greatly appreciated, Your Honor. I just want to reiterate the 17 total cycles that he's already accumulated, the multiple failure to appears, the several convictions for the same charge. And so we believe that he just doesn't have any sort of seriousness, or he doesn't take the process seriously. Your Honor, the request by the state is a $2,000 surety bond, no alcohol, drugs, or weapons, a stay away from the incident location, and to have no contact with the victim in this case. And if you could sound for Ms. Scott in accordance with Marcy's law, that'd be greatly appreciated. And I'd just like to notate that the obstruction is in actuality a felony obstruction.
Okay, is Ms. Scott present and wishes to make a statement? All right, Mr. Bartels?
Yes, Your Honor, thank you. Mr. Milton is 36 years old. He indicates that, well, this is a confusing case. And looking over the warrant, I understand that he's charged with trespass. It looks like in what my client tells me, and this is not inconsistent with what is in the warrant, is that the trespass warning was limited to the leasing office. It looks like both trespass notices, from what my client told me, only applied to the leasing office. And there's no indication in the warrant that he ever actually went back into the leasing office. He indicates that he resided at this property and he continues to reside. My client told me that he actually paid his rent yesterday before he was arrested, and that rent was accepted. So from what he's telling me, he still lives there and has paid rent, and that rent was accepted. So I think there's some questionability in the warrant regarding the trespass charge. That's just not clear. He does deny the other allegations. He indicates that he would like to ask for a signature bond if he qualifies. He has lived in the metro Atlanta area for approximately 7 years. He indicates that he does take medication, and he attends a treatment program. He indicates that he is missing those classes. So that's one reason that he's wanting to ask for a signature bond. He also indicated, there's nothing in the warrant about this, but he also indicated that he's had a disagreement with the staff, that he has a service animal, and the staff at the apartments have not been accommodating that. He just wanted to let the court know that. If the court's not inclined to grant a signature bond, we would ask for a $500 bond on each charge.
All right, defendant is going to receive a split bond as follows. It's going to be $1,000 signature on the criminal trespass. It's going to be $1,000 surety on the obstruction, and $500 on the $500 surety on the terroristic threat. So he's had to make bond for the 1,500 and 1,000 is signature for a total of a $2,500 split bond. He's to have no alcohol, no drugs, no weapons, no further contact with Ms. Scott. Is there anything additional?
Yes, Your Honor, go over the bonds amount again on the criminal trespass.
1,000 signature through the jail.
Okay.
Obstruction, 1,000 surety. Terroristic threats, 500 surety.
Thank you.
Thank you, Your Honor.
All right. Best of luck to you, sir. Who do we have next?
Next is gonna be position number 12, Deontay Wilkins.
All right. Good afternoon, Mr. Wilkins. Your case number is 24 CR 003945G. In this case, you are charged with theft by taking. You understand, right?
Yes, ma'am.
All right. Ms. Washington.
This is the defendant's second arrest. The defendant is 18 years old, so we will need a co-signer. The defendant's last arrest was May 25th, 2023 for theft by shoplifting, and it does appear that the defendant is serving 12 months on probation for that case, and the sentence date was August 17th, 2023, and the defendant does meet the criteria for level 3. And once again, we will need a co-signer.
You said criteria for level 3?
Yes, I think because of the age.
Oh, okay, understood. All right, thank you. I'm sorry, Mr. Pierre Thomas, please proceed.
Your Honor, the facts of the case is that officers were dispatched to 100 Northwest Broad Street, which is the Family Dollar location, in reference to a theft. The officer spoke with the manager, who advised that an employee, the defendant, had stolen a $100 bill on, looks like September 14, 2023, and $300 worth of merchandise on September 19, 2023 from the store. The manager advised that when the defendant was walking out the rear door, he tripped an alarm, causing them to review the footage, and they discovered the theft of the merchandise. The manager also advised that they realized that they were missing $100 after reviewing the footage. The officer observed the video themselves, and the footage, you could see the defendant walking over to the cash box and grabbing an object and placing it in front in his pocket, in his front pocket. The officer observed Wilkins also concealing merchandise in a blue and white box, which he placed on a cart and walked out of the back door of the store towards the dumpster area. The officer was able to make contact with the defendant at his residence. The defendant advised that he was instructed earlier on the 19th to discard expired merchandise, which he did so by placing numerous products in a box, to which so he discarded by a dumpster. The officer returned to the incident location and observed several blue boxes, but was unable to determine if they were the same as he observed. So he was only charged with the theft by taking for the $100 bill, Your Honor. The recommendation from the state is a signature bond through the pretrial services, no alcohol, drugs, or weapons, and a stay away from the incident location. Nothing further to add.
I'm inclined to go with that, Mr. Bartels. Any objection?
No objection, Your Honor. I would just note that my client does dispute the allegations, but if he's getting a signature bond, I understand that can be addressed at a later date. I believe my client's grandmother is willing to bond him out. So if the court needs a co-signer, I think she would be the one that would be put on that, if that's okay. Is that you, Ms. Ali?
No, that's not her.
Oh, that's not okay.
What is the grandmother's name? Do you know? We're gonna have to know the name.
What's the name? Sir?
Her name is Christina Campbell.
Can you spell that for us? I'm sorry, we can't hear. Can you spell the name of the co-signer, please?
CRESCENTIA Campbell.
Okay, Ms. Washington, did you get that?
I was just able to understand Campbell.
Right.
Yeah, it's not clear.
Say it real slow.
CRESCENITA Campbell.
Okay. Defendant is going to receive a $2,000 signature bond through pretrial services at the recommended level. What was it, 3?
Yes, it was 3.
Defendant is to stay away from that location, have no alcohol, drugs, or weapons. Is there anything additional?
Excuse me, Your Honor. Miss Washington, can you put that spelling in the text for me, please? Because I still couldn't make it out. In the
Okay,
chat, if you'll put it in the chat for me, please. Thank you.
I think I have it correct. I'm not 100%.
Okay.
Is it Crescent?
Correct. Okay. And that was 2,000, Your Honor?
Yes, ma'am.
Thank you. We just haven't, it's not clear today. The audio is not clear.
It's
Thank
not
you.
perfect. It's very low. All right.
Okay.
Best of
Thank
luck
you.
to you. Who do we have
Thank you,
next?
Your Honor.
Next, Your Honor, we're going to position 13, Mr. William Williams.
All right, Mr. Williams, the case is 24 CR 003946F. You're charged with simple battery. You understand, right?
Yes.
All right, Ms. Washington.
This is the defendant's 41st arrest with multi-state interaction in California and in Tennessee. The last arrest was March 11th of 2000 for a DUI. The defendant has a 81 felony conviction for burglary, 82 felony conviction for grand theft from a person in possession of a firearm, a felony conviction in 83 and 85 for taking a vehicle without consent, in 83 battery on a person that appears to have been reduced to fighting or offensive words, and 84 felony conviction for robbery, 84 misdemeanor conviction for burglary, 2 misdemeanor convictions in 84 and 88 for theft, and 86 misdemeanor conviction for battery on a person, and a 95 arrest for battery on a person with no disposition listed on the GCIC. The defendant does meet the criteria for level 2. Nothing further.
All right.
Brief facts of the case is that on June 17, 2024, the officer was dispatched to 844 Cleveland Avenue, East Point, Fulton County, Georgia, which is a Walmart in reference to a fight. Dispatch stated that an unknown black male assaulted a Walmart employee and that he was currently in the parking lot. The officer made contact with the defendant and was able to detain him. The officer then made contact with the employee, the victim in this case, Crystal Johnson, CrystalJohnson. She stated that the unknown black male threw a shopping bag with items at her. She stated that the defendant approached her at the self-checkout line and wanted to buy a mason jar, but it had no barcode on it. And she told him that he could not purchase it because it had no barcode on it. He then became irate and began to call her a fat bitch. She stated that she canceled his transaction and attempted to grab both of his bags, at which point he snatched one of the bags back from her and that and stated that he was going to pay somewhere else. She stated that she attempted to place the mason jar in the return section, to which point he followed her and continued to call her a fat bitch. The victim stated that the defendant then approached her again and threw the shopping bag that had the items in it at her face, striking her with it. The officer made contact with the loss prevention employee, Demetria Parrish, who provided him with the surveillance footage of the incident, and the officer observed the incident on camera. Fortunately enough, our office was able to get in contact with the victim in this case. She states that this is the first time that she has seen the defendant. She confirmed the events in the warrant. She said that her head hurt for a while after the incident, although she did not seek medical attention. She states that she'd like no contact, MHET, and stay away from the incident location. Your Honor, this is his 41st cycle, and then we think that this $600 surety bond, as currently set, is more than reasonable. Your Honor, the recommendation from the state in addition to that is a no alcohol, drugs, or weapons, a stay away from that incident location, a no further contact with the victim in this case, and the completion of an anger awareness course. And if we can sound from Ms. Johnson in accordance with Marcy's law, that'd be greatly appreciated. Nothing further to add from the state at this time.
It was a $600, you said?
Currently on a $600. We think that is more than reasonable given the 40.
Currently 600, right?
Yeah.
And I'm sorry, and the victim's name again?
The victim's name is Crystal Johnson.
All right, is Ms. Johnson present? All right, hearing none, Mr. Bartels?
Yes, thank you, Your Honor. I've talked with Mr. Williams about his case. He does dispute the way that the incident was characterized in the warrant, but he understands that he can have a trial or an evidentiary hearing later. Pretrial has given his history. It sounds like they're willing to have him. He does have the arrest he has, but it looks like that was about almost a quarter of a century ago or longer. The report I have is that the last arrest was 2000. So we would ask the court to consider a signature bond. He was just laid off from a job. He was working at Pitney Bowes as a warehouse employee. He was laid off 2 weeks ago, but he's looking for another job. So he has a history of being stably employed. And if the court is not inclined to grant a signature bond, we would ask that the $600 bond remain where it is.
All right. Defendant is going to receive a $2,000 signature bond through pretrial services at level 2. He's going to take the 1-day anger awareness course, have no alcohol, drugs, or weapons, stay away from that Walmart location, and have no contact with Ms. Johnson. Is there anything additional?
Nothing further, Your Honor. Thank you.
All right. Best of luck to you, sir. Who do we have next?
Your Honor, you said 2000, correct?
Correct.
All right, position number 6 and position number 7, bond was paid.
I'm sorry, what was that?
Position 6 and position 10, they paid their bond.
All right, so that's the entire calendar, correct?
That is correct.
All right, Miss Ollie, did you come up with a name of another person?
Yes, her first name is Carla, Karlee. Last name is Ollie, Ollie.
Okay, Karla.
Last name is Ollie, Ollie.
Okay, so the bond is going to remain as Judge Morrow indicated yesterday, but we'll make the person that's going to co-sign the Carla Ollie.
Your Honor, Judge Morrow did just respond to the email that I sent and stated that he would be fine with the bond modification that I sent.
Okay, well, if he's going to sign that, let him sign that order then, and he could do that, and we won't do that then. All right, we'll let it rest with what Judge Morrow's going to do. Okay?
Okay.
Thank you.
Thank you.
All right. Take care.
Bye-bye.
All right, Miss Bridgewater, will you review the calendar for me then?
Yes. Position number 1 is reset further notice with a $1,000 SOB through the jail. Position 2 is going to the SAP calendar, which again, the SAP date is July the 2nd with a total $10,000 good bond. 3 is reset further notice with a total $3,500 SOB through pretrial. Position 4 is reset further notice with a $9,000 SOB through the jail. Position 5 is going to the SAP calendar with a total $2,000 good bond. Position number 6 is reset further notice as the defendant has been released. Position 7 is reset further notice with a $6,000 SOB through the jail. Position 8, reset further notice with a total $4,000 SOB through pretrial. Position 9 is going to the SAP calendar with a $2,500 split bond. And for some reason on position number 9, I just want to make sure I have these amounts correct on the charges. I have criminal trespass is a $1,000 SOB through the jail. On the willful obstruction, I have a $1,000 good bond. And also on the terroristic threat, a $500 good bond. Am I correct in saying that?
Yes, ma'am. Correct.
Okay, very good. Okay, position number 10 is being reset further notice as the defendant was released. Position 11 is reset further notice with a total $3,500 SOB through pretrial. Position 12 is reset further notice with a total $2,000 SOB through pretrial with a cosigner of Crescent Campbell. Position 13 is reset further notice with a $2,000 SOB through pretrial. And for our add-on case, it's going to the SAP calendar with a $1,000 good bond. Are there any questions, comments, or otherwise?
I think that's it.
All right, everyone take care. Enjoy the rest of your Juneteenth.
Okay, let me, Miss Atai, Are you gonna send me that order so that I need for you to send it to me. Did Judge Morrow sign it or will Judge Williams need to sign that order?
Send that to Judge Morrow, please. If he
I'm sending it
indicated,
to him and I'm sending the email right now and I included you on the email, Ms. Bridgewater.
Okay, I just need a copy of it after he signs it so that I can submit it to the jail.
Thank you.
thank you all. Take care.
Thank
All
you,
right,
everybody.
bye-bye.
Bye-bye.
Goodbye.